Hi everyone, welcome to our training this afternoon. Today we have Disability Rights California here to talk about understanding your rights to file for due process or a compliance complaint when you have a disagreement with the school district. First, for anyone who's new here, we just want to briefly share about what the FRC does here in San Mateo County. We serve families who have children with disabilities between the ages 0 to 22. And we are staffed by parents and caregivers of children and young adults with disabilities. And we provide support, information, resources, and referrals to navigate the systems. We also offer trainings, support groups, a resource binder, and a monthly e-newsletter. We are funded in part by the Department of Developmental Services, DDS, as well as the California Department of Education under the Special Education Division. I want to give a disclaimer that the FRC is not a legal firm or legal services agency, and we cannot provide any legal advice. Any information provided by us should not be considered a means of taking the place of legal advice that must be obtained through an attorney. With that, we invite you all to connect with us, and we'll put our contact information in the chat. Thanks, Gabriella. I also want to introduce our FRC team who's here with us tonight. My name is Iris, and I'm the FRC training coordinator. And here with me today, I have FRC coordinator Gabriela Diaz Santos and Patricia Idrugo, our FRC supervisor. Oops. Next, we just want to go over some general housekeeping items to make sure our training runs smoothly. We will be recording this training to make available on our FRC video library. So we ask that you please mute yourself when not speaking to avoid any background noise, and please be respectful throughout this training. This training will be presented in English today, and we're also offering this training in Spanish on Wednesday. And we'll put the information, the registration link in the chat. We are also offering live automated captions today. So if you'd like to view the captions, you can go to your Zoom settings bar, find the CC icon, and then click to show captions. We'll do Q&A at the end of the presentation, and during that time, you can use the chat box or raise hand feature for any questions and comments. We encourage you to refrain from sharing names or detailed information just to protect your privacy and other families' privacy as well. After this training, we will be sending out 2 surveys, one for us, the FRC, and then one for disability rights, just to collect your feedback on how the training went. The surveys are anonymous and helps us to understand how to improve our trainings for you all. And last, we will be sending a follow-up email tomorrow with all of the links and materials shared this evening. If you happen to see a link is not shared in the chat, don't worry, you'll receive it by email tomorrow. So no need to worry. And I think that's it for me. So now I'll turn it over to disability rights, everyone.
Thank you so much, Iris, and welcome everyone. Thank you for having us today. On behalf of my team, Maria Urarti, our senior attorney, and Mari Cruz Magdalena, our senior advocate, who will be presenting understanding the due process and compliance complaint. For those who don't know about DRC, just wanted to share a little bit of information about us. We were formerly known as Protection and Advocacy. We are a nonprofit organization founded in 1978. We were federally mandated to provide legal services for people with disabilities. Some of the issues we work on can be anything from special education, public benefits, regional center services, employment, and so forth. We have offices in Sacramento, Los Angeles, Bay Area, and San Diego. Our smaller offices are located in Fresno, Ontario, and Modesto. And I'm going to go ahead and turn it over to Maria. But before we do, if you have any questions, please hold off till the end. You can type it on the chat. We just ask that you make it as general as you can. We will allow you to unmute later and ask your question as well. And we will ask the host to stop the recording prior to the Q&A. So thank you, everyone. And to our team, Maria or Mari Cruz. Thank you.
Okay, I will start with the first part. Um, Thank you everyone for being here. Uh, my name is Maricruz, as Lani just mentioned, and today we're going to be talking about the due process and compliance complaint through the special education system. Next, Lani. Our goal today is to talk to you all about the different processes available to address complaints and disputes with the school system. So we're going to be talking about the compliance complaint process, due process, and civil rights complaints. So first, I would like to introduce one of our most important publications in our website, and it's the manual for parents of children with disability. We have a manual that consists of 16 chapters. It includes information on special education, starting with the eligibility process all the way to how to resolve disputes and disagreements with the school system. In between, we can find information about assessments, services available through the school system, the least restrictive environment, which is school is responsible for educating children with disabilities in the least restrictive environment. So it is a very complete publication. It is quite long, and that's the reason that we have divided it into chapters to make it accessible and easy to read. So I encourage you all to review our website when you get an opportunity. It has a lot of really helpful information written in a very friendly format. And of course, if anybody has any questions regarding this information, you can always give us a call. Our 800 number will be available at the end of this presentation. Next page, please. Okay, so I'm briefly gonna do a run through the special education system, sort of the roadmap leading to getting services for individuals with disabilities. So if the first step, it's really identifying when a child has any if there are any questions or concerns regarding the learning process in regards to development and education. Your special education is available starting at age 3. And again, the first step into getting special education services is to identify those needs or those concerns that might lead to services for special education. And once there are needs or concerns identified, parent and or a school staff could make a referral for special education services. And the first step would be to assess the areas of concerns to identify if in fact the kid has a disability that would qualify for special education services. And so the assessment process, it starts with the parent and or staff, again, reaching out to special education. Once that referral has been done, the school district has 15 days after receiving the request to present an assessment plan for parent to sign. Assessments cannot be initiated until parent has signed the assessment plan. After the assessment plan has been signed, the school district has 60 days to complete the assessment plan and to hold an IEP meeting to review the findings. And if the child is eligible for special education at that point, develop an IEP, individual education plan. And so what the IEP is is a contract. It's a written contract between parent and the school district about the services and the supports that the student will receive through the school system. So the IEP team, includes parents. It's a very important member of the IEP team. It would also include someone from the special education department and anyone who will be working with the student and or providing services. And so again, the IEP is a legal binding document. Everything that the school agrees to do or to provide for the student has to be written into the IEP. There are students who might not qualify for special education, but they might still have needs related to a disability. So though there are accommodations that could be provided through the 504 plan. And the difference is that the IEP has a lot more protections than the 504 plan, and the 504 plan typically provides accommodations, not services. Services could still be provided through the 504 plan, but typically when student qualifies to get services, they put them through the IEP rather than through the 504 plan. So the after the IEP team meets and agrees to the services and supports, the IEP should be signed by the parent. So once the IEP is signed, then the school has to start implementing the services. The IEP should be reviewed at least once a year. Parent and or the school can still agree or make requests to meet as needed. So the school district does have 30 days after parent requests an IEP meeting to hold the meeting. So if parent identify any needs or concerns, something that needs to be reviewed or changed in the IEP, parent can request an IEP. The school district has the 30 days to arrange the meeting. Any changes to the IEP should be included into the document, and again, parent have to sign in agreement. Parent can also disagree with any services or recommendations through the school system, and those differences are the ones that are to be addressed through the due process, and we're going to be talking more about that. So at age 16, the school district should initiate a transition plan, which would include services that would help students to prepare for adult life. And that might include services such as preparing for higher education, transportation. There are students that might need some support with financial assistance, such as handling their own money, managing a bank account, do shopping and things like that. So there are also students who have behavioral needs. And so if there is, the school district cannot suspend students with behavioral needs for more than 10 consecutive days in a school year. If that is happening, then the school district has to hold what is called a manifestation determination meeting to determine if the behavior is part of the, or it's a manifestation of the disability, or if it's not. If it is part of the disability, a manifestation of the disability, the school district has to provide additional services and supports instead of continuing with the suspensions. If the behavior is not a part of the disability, then the school district might proceed with the expulsion. the assessment process, the school district is required to conduct assessments at least every 3 years. And that's after the eligibility has been established and the IEP has been put in place. And so the school district has to conduct reassessments at least every 3 years to assess the progress and also to identify any additional needs and then support that the child might need. Special education services go up till the age of 22. So for students, there might be students who are in special education and they are on track for graduation. And so if the student receives a diploma or completes all the requirements for graduation, then they exit the school system at age 18. Now, for those students that does not meet all the requirements for graduation, and they will continue to benefit from special education. The special education services will continue till the age of 22. At age 22, the special education services end completely. Next page, please. So the different processes that are available to address concerns, disputes, and implementation issues with the school district includes the compliance complaint process, which goes through the Department of Education. And then we have the due process hearing, which goes through the Office of Administrative Hearings. In an effort to resolve things at a lower level, there is the resolution and mediation process available before the actual hearing takes place, and we're going to talk a little bit more about that in just a little bit. So we also, there is also the Office of Civil Rights Complaint, and this kind of complaint is available for concerns regarding disability-related discrimination. So through the Office of Civil Rights Complaint, you cannot address issues related to the education or services. So it will not be an appropriate forum for those. And for that, we have the due process hearing. So the Office of Civil Rights Complaint is specific to address, again, issues related to discrimination based on disability. They do hear other kind of discrimination issues such as genders, color, race, but again, it does not address the special education issues. Next page. So when parents and or the school district disagree with issues such as eligibility, placement, program needs, and other related services, those are examples of situations in which the due process is would be the legal remedy to resolve these disputes. Next page. For the due process, there is a 2-year status of limitation, meaning that you cannot file claims older than 2 years. So it is important that if you have any concerns or disputes with the school regarding your child's education, that you do not wait too long, because again, the law will prohibit any claims that are older than 2 years. The due process hearing goes through the Office of Administrative Hearings. Again, it offers a resolution session, mediation, and then it will issue the administrative law judge appointed to the case will issue a hearing decision. The school district is typically represented by an attorney when they go to a due process hearing, and parent, it has the right to request legal counsel as well. And so there are attorneys that will take special education cases in a contingency basis. There are some that they might offer low cost, and there are some others that are free. When you, if anybody's in the situation where they need to hire an attorney, it is important that they sign a contract where it specifically states parents' responsibility in regards to fees, so that parent might not be surprised or at the end, learn about any kind of a specific excessive cost or anything like that. We are including here a list of low cost or free attorneys, if just as a reference. Next page. So we have an example here for a due process, and it says Carlos is a second grade student, and he struggles with paying attention in class. He also has problems socializing with his classmates. Last year, he started to get in trouble for aggressive behaviors. He has an IEP and is eligible for an IEP under attention deficit, hyperactive disorder, ADHD. The school wants to place Carlos in a separate school for children with behaviors. His family wants to keep Carlos in the general education class. His family also thinks that he qualifies for special education based on autism. So here we can identify that there is a disagreement between the school and the parent in regards to placement. So we know that disagreements or disputes are to be addressed through the due process hearing. There is another important component here. It says that the family thinks that he qualifies for special education based on autism. That is something that has not been identified by the school district according to the scenario that we have here. So if parents or school staff have any concern about additional disabilities or needs, parent might request an assessment specifically to test or to assess the student to determine if in fact the student will fall under the category of autism. So autism is not an assessment that would be generally done by the school district unless there are indications that the student might have autism or there is a referral for it. So, and for that reason, it is important that parents address this specific concern, perhaps even before filing for due process or trying to address the issue of the placement through the due process hearing, because I mean, getting right disability diagnosis is important to determine the services of the student. The other thing that it's in play in this scenario is the aggressive behaviors, and that too we would suggest to request assessment to identify the triggers of the behavior and how to deal with those behaviors in an appropriate way, perhaps before we consider a change in placement. Next, please. So if the parent files for due process, the district must offer a pre-hearing resolution. Sorry. If the district files for due process, the district does not have to offer a pre-hearing resolution. And attorneys for the district might not attend the pre-hearing resolution unless the parent is represented as well. So if parent doesn't have an attorney, the school district cannot bring their attorneys to a pre-hearing resolution. The parent and the school district must be able to discuss the basis for your complaint, and the district should be given an opportunity to resolve the issue before getting to the due process hearing. If there is an agreement that comes out of this meeting, it must be in writing, and it must be signed by both sides, the parent and the school, so that the agreement is legally binding and that it could be enforced in court. So either you and or the school district has 3 days after signing the agreement to revoke. So if you go into this meeting and reach an agreement with the school district, but as you go home, you think about it, or you're able to consult, get some legal advice on this, and decide that this was not something that you in reality wanted to enter into an agreement with the school, you have 3 days to revoke that agreement. The resolution session must occur within 15 days of the district receiving parents' request for due process, and it must be finished within 30 days of the district receiving the parents' request. And now I am gonna pass it on to Maria. She's going to talk about the mediation process.
Thank you. So we're going to go to the next slide. Okay, mediation. So if you're going to have a mediation, it's going to be before an administrative law judge from the Office of Administrative Hearings. It's not going to be the same judge who is going to hear the appeal, right? And this judge is there to try to get both sides to agree on all the issues or some of the issues. Because if you resolve some of the issues, it's less issues you have to go to due process. So you'll see that in the school context, or due process or special ed context, that the timelines are really fast. And so it's if you sometimes the timelines are extended for this or that, but your mediation is going to come quickly, and then so will the hearing. So what is said during the mediation is going to be kept confidential. So what does that mean? Let's say, for example, that the district offered at the mediation 100 hours of compensatory services, but you decided that that wasn't enough and you said no. And so nothing was resolved with regard to that issue at the mediation. And now you're at the hearing, and the school district is now offering only 20 hours of compensatory services. And you turn around and you say to everyone, including the judge, but at the mediation, the school district offered 100 hours of compensatory services. That's a big no-no. You cannot bring up anything that was said during the mediation at the hearing. That's what is meant by confidential. Now, the due process is actually an administrative hearing, right? It's going to be through the Office of Administrative Hearings. You have 2 years to file for due process from the date of the alleged action. So due process has to do with eligibility, with placement, and with services. So you wouldn't want to wait 2 years to file your due process, to file for due process. It's 2 years where your child may not be getting services in the wrong placement. So you actually want to try to file for due process as soon as possible. It has to happen within 45 days. So your mediation is obviously going to be before the due process hearing. It's going to be heard by an impartial hearing officer, although I've heard that sometimes the hearing judges don't seem as impartial. I'm not going to lie to you. I've heard that these hearings are hard, and that the majority of the times the districts are winning on these cases. So, that That's what's happening in this environment. What it means by not a formal trial, it means that you're not going to go like into a superior court, uh, you know, uh, or you're not going to go to federal court where you have a judge who's at the bench and is wearing a robe and, you know, you've got your jury. It's nothing like that. You're going to go into a room. The judge is going to be at the head of the table. One side sits on one side of the table, the other side sits on the other. I think that's what it is meant by it's not a formal trial, but it certainly can seem to people to be very formal in its process. And like we've said before, chapter 6 of the SIR manual has a lot more information on mediations, due process, hearings, pre-hearing resolution conference, and you can go there for more information. Next slide. So compliance complaint. It's really important to understand when you can file a compliance complaint. So if the district has violated your rights, your special education rights or procedures, in the law, there are a lot of sections where it talks about, oh, the school district has, once the parent files for or asks for an IEP meeting, it has to be done, the meeting has to be held within 30 days. Or if you request the record, your child's records from the school, they have to provide those within 5 days of your request. So there are timelines within the law where the school district has to do certain things. And so when the school district isn't doing the thing by the time that is allowed or is violating your special education rights, then that's when you file a compliance complaint. You might be asking yourself, well, what do you mean violating my rights? Well, you need to know what the rights are, right? And a good way to start learning about what the special education rights are to go to our manual, our special education rights and responsibilities manuals to learn about that. So these are examples of when you would file a compliance complaint. So let's say that the school district isn't providing your child with a service that's in the IEP. That's a violation of your child's special education rights because the law says that services that are agreed to in the IEP have to be provided. Failure to assess or refer a student to special ed. School districts have an affirmative obligation to identify and assess children they think may benefit from special education. So failure to assess a student is in violation of the law. It's in violation of the student's rights. Failure to follow timelines for assessments. That's, if they're not doing the assessments by the time allowed in the law, then that's a violation of the rights of the student. Parents have the right to be at the IEP meeting. And so if the school district holds an IEP meeting without inviting the parents, that's a violation of the student's rights. And if the student wins at a hearing and the district fails to implement that decision, that's a compliance complaint because the law says that decisions need to be implemented. Now, we've talked about compliance complaints and due process, but I also want to let you know that school districts generally have what is called alternative dispute resolution. So ways of trying to resolve issues short of filing a compliance complaint or going to due process. You can reach out to your district to find out what they are. But you need to realize that if you are going to enter in and try to resolve the matter through the district's alternative dispute resolution, it doesn't stop the time for you to file a compliance complaint, the time for you to file due process, the time for you to file any complaint. The clock keeps on ticking while you're trying to resolve it informally with the school. Just you need to know that and don't be under the false assumption that while you're trying to resolve things informally with the school, all of these clocks on all of these times to file these types of complaints and for hearing continue to go. They continue to tick. Next slide. So this is an example of when you would file a compliance complaint. So Ms. Marquis, she requested a copy of her daughter's records on January 15th. She also requested an IEP meeting. It's now August. Lots of months have gone by, and she hasn't received the records and she hasn't had that meeting. Well, there are two violations of the student's rights here. The first one is she hasn't gotten the records. The school district had 5 days from the day of request to get those records to the mom. So they are way out of compliance. The second one is they should have held the IEP meeting within 30 days of the mom requesting it. We're now into August. They're way out of compliance here. So these are two reasons for filing a compliance complaint. And the compliance complaint is filed directly with the California Department of Education. Next slide. You have 1 year to file a compliance complaint with the California Department of Education. So remember when I said if you're trying to resolve the matter informally with the school, that time to file your compliance complaint keeps on ticking. So you only have a year. And California Department of Education will have 60 days to investigate the complaint and then send you their results. And it may mean, the finding may be that the school is out of compliance and it'll require the school district to come into compliance. And this is the address where you would file the compliance complaint. And there are links here to more information about all of this that you can look at. Next slide. Okay, Office of Civil Rights complaint. When we're talking about disability discrimination in the context of schools, we're talking about different types of discrimination. So for example, if my child uses a wheelchair and he can't access the desk in his room, in his classroom, because it just doesn't fit the wheelchair, as a reasonable accommodation, I can ask the school to provide him with an accessible desk. That's a reasonable accommodation. It's not going to cost the school a lot of money to do that. But if they deny my reasonable accommodation, that is a form of disability discrimination. Yet another example of disability discrimination would be that his classroom they're going to have a field trip next week, and they're going to go up to a local mountain and hike. And they say to my child, well, because you use a wheelchair, you're not going to be able to go on that field trip. Well, that's a form of discrimination too, because of his disability. And these types of complaints are filed directly with the U.S. Department of Education, Office of Civil Rights. Next slide. Okay. A short time to file these complaints. You have 180 days from the date of the discrimination. So if my child was told today, December 9th, that he can't go on that field trip because he's in a wheelchair, then the day starts from today. The 180 days starts from today. You might be able to get a waiver of the time, but it's very hard to show good cause for filing a late complaint. And this is the office that you would send the complaint to. There is no timeline for investigating a complaint of disability discrimination, so it could take quite a while for that to happen. Next slide. Okay, here's an example of a complaint that you would file for disability discrimination with the Office of Civil Rights. So Anna's in special education day class in high school. So the school is undergoing some construction. So in order to complete the construction at a faster rate, the high school has shortened the school day for special education students by an hour a day. And it only applies to special education students. Well, this is a form of disability discrimination. It wouldn't be a form of disability discrimination if it applied to all of the students in the school, right? But they're singling out kids with disabilities. Next slide. So lastly, we are including links to a lot of resources. Some of these resources are on our website, and we've been referring to our Chapter 6 of the Special Education Rights and Responsibilities Manual. And there's an appendix in that manual, and in that appendix, there are sample letters, and there happens to be a sample letter, compliance complaint sample letter that you can look at and adapt to your situation. Next slide. So we have come to the end of the presentation. We are going to put our 800 number, it's our intake line, in the chat. So if you have any questions after we end this presentation, you can always give us a call and go through our intake process to see how we can help you. I also invite you to go onto our website and learn about us and the kind of work that we do. The kinds of cases that we take on. So we provide anything from counsel and advice to representation in administrative hearings, state and federal court. So, okay, so we can open it up to questions, comments. If any of you have gone through a pre-hearing resolution conference, mediation, if you've gone to hearing, would love to hear how it went for you.
Okay, thank you everyone so much.
Yeah,
for,
and I just also want to mention, if you have also, and you live in San Mateo County, you can contact the Family Resource Center so we can help you to brainstorm ideas and also get a little bit more input in some of your comments, like why they deny the meetings, you know, it's the IEs. I think sometimes communication, we help parents to sometimes prepare their arguments, obviously with their own words and their options, and then we guide them through the next steps. And sometimes we do have to sometimes request some support from Disability Rights California to help you also as well.
Thank you
Thank
for
you
that
for being here
reminder.
today.
Thank
Of
you,
course.
Patricia.
All right.
That
Good
concludes
night,
our
everyone.
briefing. Thank you everyone so much. As a reminder, we'll be sending out the follow-up email tomorrow. Thanks.
Bye, everyone.